with. What I want to spend the last 10 minutes or so here is on how we're going to get there. This is the decision that is most important. I'm going to kind of go through this so I don't take too much of your time. And obviously, I am available to answer more questions about any of this. But to help people think through your options for how to navigate life on Separation Island and how to set the tone for what kind of relationship there's going to be going forward, I like to set up a grid here, a chart. This appeals to some people. Some people go, it's kind of goofy, but think of an x-axis and a y-axis. Think about on the left side of my chart, the higher you go on this chart, the more time you're going to spend and the more money you're going to spend on resolving everything that has to do with separation. And if you look then at the bottom, we're going to talk about as you go from left to right, you're going to increase the amount of control that you as parties have over the negotiations and the decision-making process. And you're going to increase the amount of privacy you have. And so this is a chart that kind of is to show you, relatively speaking, how these different types of dispute resolution track on these measures. And then I've got one line that sort of runs counter. It's a red line that runs backwards. It's the highest where the time and cost is highest and the privacy and party control on the left side here is closest. And that's the stress factor. This red line is how stressful is it going to be? And of course, the more time and money that you have to spend, the more stressful it is. The less control you have, the more stressful it is. And the less private it is, the more stressful it is. And keep those in mind as I talk through each of these options that fall at different places along the graph. Let me dig right into it. The first and easiest one is, of course, we can work it out. If you and your spouse can sit around the kitchen table and work everything out and kind of come up with stuff, and I've known people who can do this, then you do it yourself. And you might get a lawyer to help with just the technicalities of getting a few things filed. There are programs like WeVorce and some others that will sort of put together agreement for you that presumes that you've been able to negotiate an agreement. But lots of times, if the issues are simple and the split is amicable, if a couple just decides, you know what, we made a mistake, this isn't working out, we need to part ways, and they both agree, and they just want to take their stuff and go, then you can sit down and you can figure out how to divide up stuff, and maybe somebody pays money, maybe they don't. If you can do this, it's great. The problem is, of course, if you've gotten to a place where there's enough disharmony, enough dysfunction, enough frustration that you want to split up, are you going to be able to stay at the table and have this kind of discussion? Usually that's a tall order. So for a do-it-yourself kind of just working it out, requires the highest level of trust and cooperation. It requires really effective communication skills. You got to have equal knowledge of the finances already. And if you have kids, you've got to really be dialed in on, we're both focusing on what's in their best interest, period. You may still want to have lawyers available to draw up an agreement, and you might need some assistance with court orders at some point in the process as well. And that's kind of important. It doesn't mean no lawyers ever. Certain things, as I might mention later, that have to do with equitable distribution, if you have retirement accounts, things like that, you got to have a court order. And of course, you're ultimately going to have to get the order of divorce, which you can do yourself, but again, a lawyer can help with. So great option, again, for some couples. But most folks who get to this point can't quite work it all out themselves because the feelings are too raw and it's just too painful. So another option that some couples choose, and that I provide here at Osborn Conflict Resolution, and I know several other people who provide here, is pre-litigation mediation. And mediation is basically, don't get confused with meditation, that's a different word. Mediation is a neutral third party, assist the parties to negotiate. In other words, if you run into those places, we've agreed on 3 or 4 things, but we don't agree on this, a neutral person can come and help listen, the sides listen to each other, and each will maybe give something up for the other one's sake, and this person helps you work it out. It is voluntary. You'd have to both choose to do this. And the mediator, keep in mind, is not a judge. A mediator is not somebody who has any decision-making power. The mediator is just a facilitator of communication, like a broker, if you will. And there's only one of them typically. They don't have any authority to rule or make anybody do anything. All they're doing is they're almost kind of like a counselor, but with legal eyes is sort of another way to look at it. The mediator can help you identify, hey, did you think about this issue? Some couples do this. When you're talking about custody, here are 2 different options for how you can work out custody and visitation. Here's the trick part, though. The mediator can't give legal advice, partly because the client is technically a couple. Mediator actually doesn't have to be a lawyer. There are some non-lawyers who provide mediation services to separating couples. Again, they're going to be hampered even more so. They can't give legal advice. They wouldn't know what to say if they did. And a mediator can't help you draft the agreement. That's another problem with mediation. They can help you kind of put some things on paper, but you're eventually going to have a lawyer probably draw up whatever settlement agreement or consent order comes into being. But there's no obligation with mediation. And the good news, and the reason it's down in the part of the chart that it's in, is because it's private and confidential, and it's fairly low cost. You might have some cost for the mediator services on an hourly basis, or some will do a flat fee, but you'll share those costs. It does require information sharing. So again, there's no hiding the ball in this saying, well, you can't find out about my secret bank account or this or that, or and you have to explain kind of what your expenses are, things like that. So this also requires a high level of trust and really good communication skills. It's really best when the issues, again, aren't very complex. There might be a few issues that you need some help, and the parties are open to cooperation. So it is an option and is a service that I provide, but reluctantly because of that, the limitations. Now, the next item that's a little bit higher up the chart, which is a little bit more cost, a little bit more time, but around the same level of privacy and level of client control in the same exact neighborhood, and that's collaborative law. And collaborative law is a different approach altogether. Collaborative law is when each party hires a lawyer who is trained to use negotiation tools to reach an agreement. So this is not hiring a lawyer to go to court and start filing things. This is hiring a lawyer. It's basically, I like to think of it as hiring two mediators, basically. A person who's neutral and who's working towards resolution, but each party has one so that each party can get their legal advice, can get advocacy, can have private discussions about, hey, what's best for me? What would happen if I went to court? How would it be different? In collaborative law, we engage in what's called interest-based negotiation. We don't take positions. We don't say, I will only do that if you'll do this. What we do instead is say, hey, what's important to you? What matters to you? Is it quantity of time with the kids? Or is it, you know what? I'm not sure I need as much time quantity with these children, but I darn sure want it to be when I'm awake and alert and have some energy. So getting them every night during the week for some people is a terrible idea because they don't have any energy, they have nothing left at the end of the day, depending on what their job is. Some people might say, you know what, I don't want weeknights because I'm going to be exhausted, but you know what, the weekends are important to me. And if the other spouse says, well, you know, the weekends would be good to have a break if I've been getting to school all week. We talk about what are you interested in, what's important to you, and how are there ways to accommodate both sides. So we engage in cooperative problem solving. If we have something where we need an expert, such as if you have to value a business, or if you have kids who are struggling with health issues or mental health issues, and you want to find out what's the best environment for them, what we would do in collaborative situations is use joint experts. Instead of each going and hiring an expert and having them argue with each other about who's right, we would jointly hire one and agree to use their opinion as guidance. And again, nobody's deciding anything at all. In collaborative law, a couple things that are super important to pay attention to, though. If you decide to choose this option, the attorney that you work with would have each spouse, or the attorney that each spouse works with would have that person execute a collaborative law participation agreement that goes through all the rules and how the process is going to work. In pure collaborative, in what we call pure collaborative approach, the lawyers who sign on to be the collaborative lawyers have to actually commit to withdrawing if the process doesn't work. In other words, if you reach an impasse and you can't work everything out, those lawyers basically say, well, my time is, because my goal is only to try to get you to settle or help you to settle. It's your choice, it's your control. But if you choose to go back into the litigation route, you want to go and fight things out by the means we'll talk about in a minute, then you get a different lawyer to do that. And the nice thing about it is it changes the incentives a lot. When I'm working with couples collaboratively, I really don't want them to end up, fighting and going to court. I'm not going to handle that, so I have no interest in them doing that. It's their choice, but my incentive is only to help people get things worked out. And so nobody can say I have any divided loyalty there. And I'm not saying that people who do litigation are unkind or not sensitive on that or unethical or any of that. They have to help you make those difficult calls as well. But when you work with a collaborative lawyer, they've only got really one goal. That's if you can reach a resolution, they're going to help you get there. And collaborative law involves the sharing of all relevant information. If you participate in collaborative law, the ideal format is you have a series of meetings. Instead of having one mediation all in one day, you can have a series of meetings scheduled at your convenience and done in bite-sized chunks and the right amount of time that everybody can handle at the time, so that everybody's at their best for decision making. We're trying to set the stage for cooperation and stepping back from the acrimony and stepping back from the accusations and the hurtful things that people start saying when they're really afraid or when they're really upset. Collaborative lawyers are trained in nonviolent communication, in how to help people work through the emotional side of things, which is present. We can't make that go away. But how do we give it its place, but not let the emotional side of things start dictating how we're making decisions and what we're filing and what we're pursuing. And those meetings are all confidential. A collaborative process can happen mostly without the court. Again, there's only certain things that you have to go to court for. Domestic relations orders that have to do with retirement accounts and the divorce decree itself. But everything else can be worked out in private meetings with the lawyers there able to counsel their clients and help them draft up the agreement language, work through it, and suggest ways of other kinds of solutions that the couple might not think of on their own. If it's not successful, then you have some options. If you try the collaborative process in good faith and everybody commits to it and works out, but it doesn't, you don't reach agreement on everything, you can still go and bring in a mediator at that point. You can bring in a neutral person to help bridge the last gap if the collaborative lawyers were not able to help you do that. It doesn't happen that often, but it is an option. It doesn't mean you have to go all the way back to the litigation scenario. Or if you don't want to mediate, or if you mediate and that's unsuccessful, then the couple can return to the litigation process. You haven't lost any rights there. You've shared information, but spoiler alert, in litigation, you're going to end up sharing most of the information anyway. It's just going to be after a lot of back and forth and a lot of lawyerese objections and all that stuff. So collaborative law, again, is a good option to consider. It's my recommendation, my bias. I'll reveal that very straightforwardly. Please talk with other collaborative lawyers about it if you want, other opinions. But it's best for people that do have some difficult legal issues. Collaborative law presumes that you're not just agreeing on everything, or else you wouldn't need collaborative lawyers. It's when you have challenging relational dynamics. And if you think, well, I'd cooperate, but my spouse is crazy, or they're mean, or they would never cooperate, we can deal with that in collaborative law. We can, if they'll buy into the process, if they'll even start it, then we can probably get somewhere. Whenever there's imbalances of knowledge and money or imbalances of power, collaborative law helps kind of right that a little bit, because each side has an advocate. Each party has a lawyer who is geared towards their best interest, is geared towards advocating for them. I advocate for my collaborative law clients very thoughtfully. It's just not antagonistically, it's not unnecessarily, it's not procedurally. It's advocacy of a different kind. But everybody having a lawyer sometimes restores those balances that have gotten out of whack. And when each party just needs that guide or advocate, and you can't just, have a mediator neutrally sitting there trying to be like, Yoda or Gandhi or something, negotiating things. But the parties have to decide that they're willing to work through the difficult issues in a way that might help preserve the friendly relationship. And the key thing about it that's really important is if the collaborative process goes well, it sets the tone for that co-parenting relationship, for how everything goes from that point forward. Now, I'm going to fly through the rest of these real quick as well. Negotiation happens. If you go to litigation, if you file court action and start making pleadings, some of you may already be at that process by the time you're watching this video. You still get chances to negotiate. You still get chances to do mediation. Those things will all still happen in time. And there's actually a mandatory mediation of custody, for example. Again, the same rules that we talked about earlier with regard to mediation are in play. A mediator is not a judge. The mediator doesn't decide anything, and you're not obligated to reach an agreement. You have to negotiate and agree. If you do, great. The lawyers are there who've been helping you, and they can help you work through things. This is also where some people find themselves after being in the court system a while. Maybe you don't have a lawyer. Some people are representing themselves. At some point, you may have to mediate. You may have to work things out. You have this option also. And if you do a mediation, that itself is private and confidential. Of course, you've already been filing court matters and things like that. You share the cost of mediation. But again, if you're doing it after there's been some litigation, then you have already spent time and money to get to this point. And if you have lawyers involved, then for a mediation, lawyers tend to do most of the communication. So the control factor is less with the parties and more with the lawyers. And this is the key. If litigation is ongoing, then it drives the timetable. Court deadlines and rules are what's going to drive the timetable here. And that sometimes helps because it puts some pressure and it puts some accountability. Sometimes this is necessary. But your cost of getting to a point of negotiating and mediating is going to depend a lot on how early or late you are able to do it in the process. Sometimes discovery, the exchange of financial information and records and school records and all that has to happen first before people are on equal footing information-wise and willing to talk. So it is an option for some people. It basically is best when there's a lot of mistrust and when there's a lack of cooperation. Sometimes you got to go to court at least and start that process. And then maybe you say, look, I'm willing to negotiate, but I've got this court process that's in the background because I don't trust you. I don't think you're going to do what you say you're going to do. You have history of bad behavior, of mistreatment, things like that. It also kicks in when the parties get tired of litigation process. And at some point, everybody gets to that point frequently. This is not fun and this is expensive and can we do something different? And that's because they're comparing it to the last option here. And I've got this labeled as litigation, hearings, and trial. You'll also hear a good bit about arbitration, and there are more family law cases being submitted to arbitration. Arbitration has the advantage of it's not within the court system, but it is still a neutral third party. In this case, it's a lawyer rather than a judge. And so you definitely can choose somebody who definitely knows family law, but they're still making a decision. They're still deciding based on the law. You're still giving up control of the process and control the outcome. And that's why this is way up here at the highest part of the grid on time and cost. And because on the cost factor, you have to pay the arbitrator for their time. So it's like a private hired judge. So you can get justice somewhat faster, but you are giving up control, giving up a little bit more privacy. It's arbitration is probably a little bit more private than litigation. But basically, this is whenever you submit your situation to a judge or to somebody else for a decision. This is the court process that you hear about. You hire a lawyer, they start filing pleadings, they start exchanging discovery, and the procedural rules of the court are what drive things. And this is where you hear about depositions and people taking testimony under oath and things like that. And, I'm not going to go into details on that. One thing that's important to bear in mind, though, is that it's often a series of mini trials. Each issue that we talked about on Separation Island, custody, support, equitable distribution, might be the subject of a separate trial proceeding by itself. Sometimes they're consolidated, some of them, but the calendars are driven on very different timetables. And it becomes a lot more about positioning and posturing and all the process that happens, or most of the time in the court. Again, it's not confidential. And so that's why it's way back to the left on party control and party confidentiality. And sometimes you're in litigation because one party has a lawyer and the other doesn't. The other person proceeds pro se. Sometimes that's how a case ends up here. One party is not cooperative at all. That's one of the worst scenarios and actually can be one of the most expensive, ironically enough. So litigation is best or arbitration is best when the parties just can't communicate at all, when one or both of them is unwilling to cooperate, when there's no trust, when you've got a real serious misconduct and power imbalance, when there's been abandonment and abuse. This is not the only way to deal with abandonment, abuse, and addictions, things like that. I would submit that collaborative law has some better actually ways of dealing with that if you have two people willing to work together. If you have somebody who is actually stuck in an addiction and doesn't know it and still going down the road, or they're abusive and they're not changing, then you might have to go to court. If they won't get to the place where they cooperate, then you might have to bring the court power to bear. Also, if there are big time assets, big time money in play, or if there are very complex custody issues, complicated living arrangements, sometimes you'll never agree. You have to have a judge make the decision, and you just have to submit that to the judge and trust that the judge will make the decision that is in the best interest of the kids, which is what they're supposed to do. Problem is, they're going to know the information that the lawyers have provided, and that's it. So That is the overview, and then you can see how these all play out. More party control and privacy as you get farther down to the right with working it out yourself. Mediation, and again, collaborative kind of ends up right there in the middle. It's definitely less stressful than litigation and arbitration, and even then mediating somewhere down the line. So those are your options, basically. And I've got some information on our website that provides a little bit more detail about that. The key is, what are you going to do? What's the best of those paths to navigate while you're on Separation Island, and thinking about the big picture when you leave that island and you're co-parenting and trying to work together? Collaborative is one option that I would submit sets the stage for that. And if there is a chance of reconciliation, if there's a chance of hope, if there's a chance that actually you're going to leave Separation Island together, then collaborative is a beautiful way to only deal with what you need to, only deal with the issues that you need to, not start any legal process, not start equitable distribution until you have to, and you can save a lot of cost, time, and money. So if you've reviewed this and you decide that a collaborative approach or an early mediation might be something that you're interested in, please give us a call at Osborn Conflict Resolution. We'd be happy to talk to you about that. But this is an important decision. It's important for you both to make, to go in eyes wide open and fully informed as you start this process. So thanks for listening, and maybe I'll hear from you soon. Take care.